All right, the Supreme Court ruling moments ago on the issue of birthright citizenship. These are the three cases that we are waiting on right now. So let me break them down for you. The first is Mahmoud versus Taylor, a case about LGBTQ books in the classroom. Louisiana versus Calais, which is about a voter redistricting map. And Free Speech Coalition versus Paxton, which would place an age restriction on adult websites in Texas. So our chief legal correspondent, Jan Crawford, is joining us now from Washington, D.C. To talk a little bit about this. Jan, you're refreshing the SCOTUS site. Anything yet on those three that we're waiting for?
We had a big one. Literally just dropped, Vlad.
Break it down for us. It's breaking news.
Oh, I haven't read it yet. It literally just went up on the website. It is a decision. I'm going to tell you just the top headline. It's a decision in the case about parents and whether or not they can opt their elementary school kids out of that story time. It's written by Justice Alito, and it says, just at the top, that yes, they are entitled to do that based on their sincerely held religious beliefs.
So, Jan, why don't you continue? Why don't you take a look through that?
The parents, as Jessica was predicting, the parents win.
The parents win on that. All right. So, Jan, while you go through that decision, I don't want to have you on camera while you're sort of reading and taking it all in. But let's bring back Jessica Levinson just again to refresh our viewers' memories. If you're just joining us now on CBS News 24/7, we, before the break, were talking about this decision, this very decision that has just come in now from the Supreme Court regarding parental opt-outs for LGBTQ books in classrooms. Jan, again, for people who are just joining us now, because I can see the push alerts going out on social media that we do have another decision from the Supreme Court. So just recap for our viewers what was up for a decision, and then we'll go back to Jan and for a debrief on it, and then we'll come back to you for your take.
Sure. So I think I maybe got three more words than Jan was able to look at here. The bottom line is that the parents lodged a First Amendment claim saying that it violated their free exercise clause rights to not have notice and an opt-out provision when their children were read LGBTQ inclusive educational materials at school. Justice Alito wrote the opinion. It looks like it is exactly as we talked about a few moments ago, Vlad, a win for the parents. I saw very briefly the majority saying that parents have genuinely held beliefs and that it substantially infringes on those beliefs not to provide them with notice and an opt-out when certain materials are read to their parents. I think this is part of a larger theme of this court being very protective of the rights of religious objectors and protective of free exercise clause rights. Vlad, as we talked about before, I think the fascinating part of this will be looking to see exactly how the court creates the standard for determining when parents are entitled to notice and an opt-out. I think my guess, again, looking extremely fast, which is that the court is going to stay fairly close to these particular facts and try and highlight that this is not open season for parents to start saying, we don't want our children to hear X and to hear Y and to hear Z, because you do want to provide school boards with some ability to dictate their curriculum. So again, this case, as we talked about before the break, I think predicted a win for the parents, a win for those claiming that their free exercise clause rights are infringed upon. And again, the real question here will be how the opinion is drafted in order to make sure that school boards can still dictate large portions of their own curriculum.
All right. Jessica Levinson there for us. Jessica, stand by. Jan, back to you. Jessica and I were talking earlier, you as well, about how this could potentially go. And it's just as you predicted, the justices siding with the parents.
Right. And this one was 6-3 with the liberals also in dissent. Jessica, she's obviously so brilliant. She's always getting it right. I mean, this is an issue that this Supreme Court has been really concerned about, kind of the people's ability to kind of freely express their religious beliefs. And the court, in his opinion, Justice Alito essentially says that, the First Amendment protects parents from having to make the choice of, sending their kids to a private school if they don't agree with some of the potentially religious messages that they feel they're getting that could contradict their religious beliefs. It's interesting because this case, the way it's come about, and I thought an argument why I was confident that the court was going to rule for the parents, the justices actually read the books that were at issue. There were half a dozen books that teachers were instructed they could pick from to read to these elementary school students, and they specifically asked about a number of these books during the argument. And while it was kind of portrayed as books with LGBTQ themes and characters, some of the books the justices suggested went well beyond that to actual, almost as someone suggested, indoctrination. And Justice Alito has attached pages from some of the books in the back of his opinion as an appendix, pages that say that kids can pick their pronouns, that they should be able to decide if they want to be a girl or a boy, embracing the idea that gender is fluid. I think that had a pretty big impact on how the justices saw this case. I think it's a narrow ruling. I agree. I don't think it's going to have a real impact to your concerns earlier, but we'll get through that one and talk about that in an hour or two.
All right, Jan Crawford for us, reporting from our bureau in D.C. As always, Jan, great to have you. Thank you so much for sticking around with us. We really appreciate it. All right, let's go to Scott McFarland, who's outside of the Supreme Court for us this morning. And so you just heard a little bit of Jan breaking down how the conservative justices ruled and how they felt about this case. Scott, what can we discern from how the liberal justices ruled?
Yeah, Vlad, pretty dense opinion, 135 pages, a pretty meaty dissent here. I was also struck by what Jan mentioned and what we see in this ruling. They actually have pictures of the books in this ruling, images from some of the pages in the books referencing same-sex marriage or gender dysphoria. In the dissent, Justice Sotomayor makes a number of arguments, one of which is pretty practical, that schools have a tradition of allowing students to opt out of certain courses, certain classes, certain larger scale programs the schools offer, but letting them out of certain conversations, certain ideas, certain themes, that may just be untenable for the schools, a remarkable burden for school districts, for principals, and for the teachers who are trying to execute a lesson plan. If it begins with issues of same-sex marriage and gender dysphoria that schools must give children and parents an right to opt out of, what's next? What else can they opt out of if they disagree with the premise that the teacher is making in the lesson plan? A practical argument in addition to the constitutional argument Justice Sotomayor includes in her dissent, Vlad.
All right, Scott McFarland standing by for us at the Supreme Court. Let's go straight to Natalie Brand, who's got some breaking news out of the White House. Natalie, what can you tell us?
Vlad, we're hearing that there's actually going to be a news conference here at 11:30. It was just announced by the president himself via Truth Social as he's really celebrating the Supreme Court decision. I'm not sure if we have that Truth Social to pull up for you, but he's calling this a giant win in the U.S. Supreme Court, saying that even the birthright citizenship hoax has been indirectly hit hard. He's saying that it had to do, quote, with the babies of slaves not scamming our immigration process. Congratulations to his Attorney General, Solicitor General, who argued the case before the Supreme Court, and the entire DOJ. So again, we are expecting now to hear from them. There's the social media post that we just received. Next hour at 11:30, after this major ruling in which, again, the justices did not rule on the merits of birthright citizenship, which is protected by the Constitution's 14th Amendment, but they ruled rather that a lower court judge cannot block a presidential policy nationwide. This was a ruling on nationwide injunctions, but it's certainly a victory for presidential power. And the president seems to want to be taking a victory lap here again. He's expected to speak with his justice team next hour.
All right, Natalie Brand, for us at the White House, where, as Natalie just pointed out, the President of the United States is expected to hold a press conference at about 11:30 a.m. Eastern Time, later, just about a half hour from now. And so we'll obviously carry that live right here on CBS News 24/7.